Hey guys. Oh, did I have the music playing? I'm sorry, my bad. So there's a... It seems that there is a new influx of people into my channel who are bringing up very, very old arguments, and I was hoping just to make a quick little video while I'm stuck in rush hour traffic on the way to a court appointment in 24 minutes. I figured I would make use of this time. Being open to the public is not a test of whether or not you should be allowed to do any form of speech. Speech would include filming. There are tests. I know for a lot of you this is very remedial and I apologize, but there are tests. They're called forum analysis. And what those tests do is they look at the nature of the forum, the nature of where you are. Public sidewalks, it is next to impossible to restrict someone's right to film. It's very hard to do. They can do it, they have done it, but it's very hard to do. Typically, any policy or law or rule that restricts your freedom to film on a public sidewalk will be unconstitutional. It's not guaranteed, but 99 times out of 100, well, they don't even try, generally speaking, but if they did, it would most likely be unconstitutional. So that is a traditional public forum. The other big thing is a non-public forum. Examples of non-public forums are post offices, courtrooms. They're open to the public, but they're not a public forum. The curtilage, the surrounding property of a jail, is a non-public forum. A military base is a non-public forum. Generally speaking, in a non-public forum, any restriction that the government makes on free speech activities, First Amendment activities, is generally going to be upheld. It is, again, not guaranteed, but generally speaking, the plaintiff loses a First Amendment challenge in a non-public forum, and generally speaking, a plaintiff wins a First Amendment challenge in a public forum, generally speaking. So if you roll up in my comments and say, hey, but isn't this a public place? Isn't this open to the public? That's meaningless. It doesn't make any difference whether or not the place where you're trying to film is open to the public. That is not the test. It might be a test under state law. You know, talk to a local attorney. It might be. In California, it is. In California, if it's open to the public, then a different test will typically apply. And that test would be basically, is the First Amendment activity incompatible with the use of that particular area? So but that's in California. That's under the California Constitution and case law that has interpreted the California Constitution. It is not the U.S. Constitution, and it will not apply outside of California. So that's something that you guys need to be aware of. When I'm telling you that you are making the wrong argument, that you are incorrect in your premise being that it is a public space, therefore I should be allowed to film, that's where you fall down. So there's that. Another thing that I'm noticing are people sliding up into my comments saying the Supreme Court ruled that X, Y, and Z. We've covered this. We've gone over it. The Supreme Court has not ruled that you can't trespass the eyes outside of a Fourth Amendment setting. And even then, they were using trespass in a different way. The trespass that they were talking about was basically an invasion of privacy. The eyes can't trespass. They can't invade your privacy. but it is a Fourth Amendment analysis, not a First Amendment analysis. You're not guaranteed a right to film. You do have expectations of privacy in public. That is how the government can restrict the use of things like cameras that can use infrared or some other technology to see through your clothes, or that's how the government can regulate people putting cameras on their shoes or mirrors on their shoes to see under skirts. That is entirely how, because you have an expectation of privacy in public. It's diminished, it's reduced, but you still have an expectation of privacy in public. And if two people move to the corner of a courtyard where they are not surrounded by anyone, they may have a private conversation there. Again, you know, it's going to be a fact-based analysis, but just be aware that even in public, there can be an expectation of privacy. So I hope that helps. Good places to start for those of you who are new to the channel is Adderley v. Florida. That gives you the kind of basic groundwork of a non-public forum. You can then look up Spock v. Greer, NAACP v. Buttons. There's a whole list of them. You could probably find various ones on my channel. US v. Kakinda, US v. Grace, International Society of Krishna Consciousness v. Lee. I mean, there's a lot. But those are actual Supreme Court cases that have actually ruled on First Amendment issues. Hague v. CIO, that's your traditional public forum. Those are good places to start on that kind of stuff, on the First Amendment analysis and forums, specifically forums. There are other First Amendment analyses, but they don't come into play as often in what auditors are doing. So I hope that helps. Thank you for watching. I'm almost to the courthouse. So thanks for watching. Have a great day.